the deposit is going to be amount of $5,000, and it's going to be out a check or money order or note. We're not doing a note. And okay, so let's talk about this here. Your escrow should be a reasonable amount of escrow. So if you're the listing agent, you want $1,000 is not covering the damages of your clients. So if you're looking back in his contract and seeing that a buyer is putting 20% down, the presumption of which is that he has 20% somewhere to put down, otherwise he's not entering a contract in good faith. There's no reason to accept then $1,000 for EMD. At a minimum, your EMD should be at least twice whatever your seller's monthly mortgage is. At a minimum, they're taking the house off the market for 2 months. You want some notable amount in that EMD section to ensure that the buyer does at least have to think twice before they walk off. Because most people in our culture now, and this is my 15th or so year in the business, or close to it, somewhere in that range. Yeah, I guess as of this month, 15 years. The same amount of money we were putting 15 years ago is what we're putting in now, and it's got a different value. And so $1,000 now is what most people were willing to walk away from and not care. It's harder for them the more money that's in. And if they're putting money down, why not put it in escrow? It's going to be applied to the transaction in the end anyways. So we want enough money there to try to offset any actual damages the seller may have, and at a minimum, a couple months of mortgage is the damage. So put a reasonable amount in there. And then if it is by note, you're going to put the date that's due. And if you are the buyer's agent responsible for collecting this, you need to stay on your client and show a history of notifying them if you haven't yet gotten the check or money order. Now, we don't accept cash, so it is either check or money order, and given the preference, we would much rather have the money order. So a few notes here. If your buyer fails to deliver the check on time, you have an obligation, and it's a legal obligation, and it is not just something we recommend, to notify the other party in writing that the buyer has not made their deposit. It needs to be before the deadline. So if you've put in here that you didn't receive it today and it's going to be 5 days from now, on day 4 you don't have it and you're wringing your hands, this is the time that you need to get the buyer and seller to agree to extend the contract, or at least this paragraph of the contract, to give the buyer more time to actually get the EMD to you. This is not a place where you wait to the last minute and hope for the best, because if you do wait to the last minute and they haven't performed, the contract is in jeopardy. It is more likely breached. The buyer did not specifically perform to the element of paragraph 3 of the contract saying he is going to make the deposit. So again, this is a pretty serious paragraph. It is always better to receive the check at the time of the offer or immediately thereafter. The contract by standard language says that your buyer needs to deliver that check in whatever time frame. And so it also will say who's going to hold it. So we're going to say ABC Realty Group is the buyer's agent, and we're going to let them hold it. This could be a settlement company or a broker. Anything other than that, it's kind of sketchy. We want to find out why. So either your settlement firm or the broker should hold it because they're bound by specific laws. And it is important to remember that the attorneys or settlement companies are not responsible to the same rules that we as brokers are. So things do change there. All right, and so this is held by ABC Realty Group. Or the buyer has delivered the deposit. If they're not delivering it already, it will be delivered within 3 days. There's additional language in this paragraph that says we, the brokerage, upon receiving that agreement, we have 5 days to get it in the bank. So we don't have 3 days to put it in the bank. That's 3 days for the buyer to deliver it. Once delivered, we then have to go and deposit it and do whatever we do with it. All right? And that's what this paragraph says. It outlines what the Virginia Real Estate Broker Board their obligations are, and it does say that we have to deposit in the 5th day. Now, under the code section, the buyer and seller can agree to other terms. We have put standard language in here, but if the buyer and seller agree that they can get it later or deposit it whenever, then so be it. But they have to agree in writing to any conditions other than that 5th day, and that's why this is actually a dynamic field that you can put anything you want in. If you leave this blank, the law by default will say 5 days, 5 business banking days. And again, we'll do other sessions on more escrow stuff at some other time. Further, this paragraph explains, as should you to your clients, that the only way that money can be deposited or given back to the client is going to be through what the law permits. And so in this case, the law permits that when the buyer gives us the money. We, the brokers who are holding it, or ABC Realty Group, must hold that escrow until the transaction is closed, because in writing it will say here that that money is applied to the transaction. Or a court has ordered us to release it, or the parties have agreed in writing, or that we dispose by any other thing that's permitted by law. As a brokerage, we could use interpleaders, and again, that's more than you really need to explain to your clients. But what they do need to know, what especially the buyer needs to know, is that we can't merely give them their money back. The seller has to sign and agree to do so, or a court has to order us to do so one way or the other. All right, and so that's it on deposits. Okay, and that brings us then to paragraph 4 under settlement. So the buyer and seller here are going to state the settlement company. Now, a couple things to remember about this is at a federal level, the buyer has the right and obligation to choose the firm in which is doing their title insurance. At the state level, they've given them more responsibility and control and said you need to be responsible, or you need to choose the settlement firm. Remember, title insurer and settlement firm are two different things. Virginia says you get to choose. So the buyer gets to choose. The seller can't come back and reject the offer because of where they elect to go. However, it's become a very common practice, although not yet reflected in the contract, over the past many years, maybe over a decade, to do split settlements where the buyer's settling in one place and the seller's settling in another. What we're looking for in this paragraph is for where the buyer is closing, because they're going to be responsible and do a bulk amount of the work. And so that's what's going to be stated here. A lot of agents are adding in some text here that say seller will choose such and such to do their side of the transaction. The paragraph does state that settlement is going to occur on or before, with mutual consent, a certain date. So the mutual consent, notice here in your contract, you're going to see areas in which there are capital letters that seem randomly placed. For example, capital D for default, or delivery rather, or lowercase d for delivery, or capital N for notice, and then lowercase n for notice. The capitalization means that it is stated elsewhere or defined by law that this is a very specific use of the word for give notice or default, or deliver rather. We'll talk about those later. But here, notice it's not calling for anything. There's no specific notice. It just needs to be mutual consent. That could be the acts of the parties, them both showing up. It should be an addendum if you're trying to hold them accountable for it. So a very common issue with agents is, well, the buyer and seller agreed that they're going to close on Thursday. And we close on a Thursday, and the buyer's like, sorry, the lender couldn't get it done. We had to go back to our original date next week on Wednesday. And the seller's all upset. Well, if you didn't put it in writing to the contrary, then it's not a mutual consent. And the buyers didn't agree to give up their rights under this clause. So it's questionable whether or not they are actually bound by Thursday just because all the parties agreed. For all of those reasons, it is much better to get an addendum executed by all those parties to agree to a certain date and time for their closing. All right? So that's settlement. Now again, we're going to choose the date of closing here, the date of settlement here. And this is a pretty important date because everything's going to be predicated on that date being achieved. And we're going to talk later about some areas where that date is important. So if you're the buyer agent, make sure that that date is far enough away that you can get done all the things that you're going to outline in your contingencies in your contract to achieve. This next paragraph is simply restating what the regulations are. And who chooses what here. So when your buyer and seller are looking over this, do explain to them that they this is restating what the statute is. And essentially for them, the biggest issue is that the buyer gets to choose the settlement company. The seller is not permitted to refuse the contract based on that settlement company. They can incentivize, though. The seller can say, you know what, we'll pay all your closing costs if you use our preferred company. And the buyer has to elect to either do that or not. But the seller cannot reject it. They can offer incentives to do other things. And then the buyer designates whatever settlement company they wish to have here. So you're going to just go ahead and enter the designated settlement agent here. And you'll notice in other places that the contract calls for the settlement agent. Those are capital letters. That's talking specifically about what's entered here. And also the contract says that this contract needs to be delivered to that settlement firm within 10 days. That's an important thing to remember, is that needs to be done as soon as possible and no later than 10 days. Okay. And then there's some other language in here. And again, one of the things that I recommend for everybody who's, whether you've been doing this for years or whether you're brand new, take this contract, sit down with it, print it out, and in the margin here, write one sentence that summarizes each paragraph. Your buyers do not want you to hear you reading this. They don't want to think this is the first time you've ever seen this contract in your life. So make sure you know how to summarize and review each paragraph meaningfully. Each paragraph, for your intent of discussing it with your buyer or seller, can be reduced to about one sentence.